First of all, the defense wants to file a motion that the judge is going to allow next week about prosecutorial misconduct, asking for mistrial, asking for the prosecutor to be recused. As you can see right now, by the way, folks, the jury is being sent home for the day. So that's it for testimony today. But what I am typically used to, or I certainly would be screaming and yelling about, is, Your Honor, I want a testimonial hearing outside the presence of the jury. I want to be able to have the prosecutor, it's good, maybe now the prosecutors would, but at least on the stand. I want to have the civil attorney on the witness stand. I want to have the witness on the witness stand. I want to know to the extent that there was tampering with the witness. And I'll tell you, Joe, what kind of sometimes bothers me about this is that if a defense attorney had done that, it's very possible a prosecutor could charge them with potential witness tampering.
Yeah, I mean, I'd agree. This is a serious problem, and the defense really, I mean, let's face it, the defense, I don't know how much deference that they've gotten as it pertains to the decisions and the rulings by the judge in this case anyway. And the prosecution would be jumping up and down if the defense had done something like this. I don't think there's any question about it. And so, sometimes these jurisdictions, it's interesting, these ones that are inclined towards death penalty and things like that. It's almost like sometimes these things get brushed aside. There should absolutely be an evidentiary hearing so that every aspect of this thing can be ferreted out so that the record is clear, and then the defense can do what it needs to do down the road. Even though they get to file a motion, well, the testimony has already happened and is already incurred. And on some level, if the prosecution brushes it under the rug, then maybe the jury is inclined to brush it under the rug and minimize it as well. And so it is interesting to me that they didn't get that hearing, that the defense didn't jump up and down for it and about it to really go down this road for some period of time. If you're not going to give us a 24-hour continuance, well, let's bring everybody in right now and have all of this discussion out of the presence of the jury and then go from there.
Yeah, Matt, I mean, I agree completely. I mean, before the witness is testifying, you need to know this data because the cross was actually lackluster. I am shocked. It could have been something that went on. I would have had that going, baby, for 15, 20, 30 minutes, depending on the witness is answering, to show I know that I'm hurting the prosecutor's integrity by saying that they put the arm on this guy, and how many other witnesses are they doing this kind of thing to? So I was really surprised. So she goes to make the motion. Do you anticipate she's going to ask to have additional witnesses testify here? I would like to have heard a lot more from who said what and who called and what was the nature and what was the tenor and what was specifically said, what wasn't said, and what did the prosecutor do? Matt, I know I'm going off on this because my trial mind's going crazy here, because the bottom line is we've all been, you may have been prosecutors. We've been in environments, I'm sure you have as well, where something that's not right is going down and you have an obligation to intercede and stop it, document it so that it's clear in the file that what happened. Thoughts?
Well, the interesting thing I hear is, the defense can continue to ask for a full hearing on this, bring in the attorneys, bring in whatever other witnesses might be needed to establish that there was some, undue influence, some misconduct. But today they were able to ask this witness about this conversation. So let's say they would have had a hearing today, and the judge said, "Well, this isn't misconduct. We're not going to let you present anything on it." Then this information never gets to the jury. They got it to the jury with still having the possibility of showing that the prosecution committed misconduct in this case. And if I was the defense, I would run with this, because we have testimony now before this jury that a civil attorney was concerned about what this witness's testimony could be, because they feel some responsibility here. Their civil case is harmed in some way. So they now have this argument that, hey, it's more than just this young man's terrible decision to go in there and murder people. The school failed him. If the school would have given him the support that he needed, he may not have done this.